true, but I can find out again today and see if I can find out an exact placement or number for Mr. Newborn.
Okay, and I'm not trying to pin down to the specifics of, hey, it will be indicted on May 6th at 2 p.m. That's not a fair request. That's not a reasonable expectation. But I think it is reasonable for a defendant, his lawyer, a judge to expect that the district attorney's office can provide a sense of, well, let's do the math. I'm making the number up. We have 100 unindicted murders. And we look back at the past month, we were able to do 5 a week. All right, there you go. If there are 100, it's going to take 20 weeks. And he's number 50, so it'll be 10 weeks from now. Ballpark. All right, good to know. I may find that's a reasonable wait, and Mr. Newborn's going to stay where he is. I may find, oh my gosh, 10 more weeks. That's too much time. I'm going to set a bond. But with no data, it makes it unfair to the decision maker to have to guess. I'm not inclined to give Mr. Newborn a bond for all the reasons that I articulated before. He was in New Jersey, serious charges, et cetera, et cetera. And I think he's a risk to the community. But Mr. Monis's strongest point is there's no indefinite detention in America. And that's sort of what it becomes when the answer is, we don't know when we're going to be able to indict it. And I'm not fussing at you, Ms. Ocom. You don't run the intake unit. I'm just sort of processing out loud because I get this opportunity, sort of where we find ourselves. And I do think that Chief Judge and District Attorney are going to need to chat a little bit to figure out a way to empower you and Ms. Sims and Ms. Hall and all your counterparts in the courtrooms to be able to share with judges and defense counsel, here's a sense of how long it'll take. And to me, it seems like the specialized units ought to be in a better position to do that than I asked Ms. Hall, when is an interference with government property going to be indicted? And if she shrugs her shoulders, I kind of get that because that's going to be in the back of the line. But with the homicides and what's at stake, even if it's a long line, there ought to be a line and some organization to it. In the sermon, so what is your ability, Ms. Ocom, to figure out if the district attorney's office already possesses the surveillance footage that was discussed? I don't think were you involved in the first bond hearing, or did the first bond hearing happen before your time?
Before my time, you are.
Okay, so you're coming in doubly late. But I do recall that when we had the bond hearing the first time, there was a lot of discussion about the club and the shooting and this and that, and reference to surveillance footage. And I appreciate Mr. Monis's frustration that, gosh, if it's on camera, I might stand down from demanding a bond motion if there's a guy wearing a Newborn T-shirt with a gun who looks just like his client, and they see him shooting. It's like, kind of hard for me to argue past that one. But he's got nothing. And so the state is in a position to say, well, the evidence might show this or that. And Mr. Monis has to rely on what his client is able to tell him, assuming his client was even there. And that's sort of where we are. Mr. Monis, your internet connection got a little iffy. Did you want to wrap up what you had to say?
Your Honor, hopefully you can hear this, because everything I said that you couldn't hear was brilliant. But, I don't know where that leaves us. I don't think I think I am concerned, just like you said. This is turned into indefinite detention with no access to the evidence against him. And, what I would ask is, I understand the court has court at 1:30. Why don't we come back? And that should be plenty of time to figure out where he is in line. Because as you say, if they're going to indict him, in the next 2 weeks, my argument is not as strong, but I don't think they're anywhere close. And I don't want to be having to file a motion, wait 6 weeks to be on a calendar, come back 8 weeks from now and make the same argument to you. and then the case is 2 months older, bond is a huge concern for me, but the case is more of a concern to me. And I'm going to be looking at about a year out from the shooting before I can even get to the state's evidence, which is, a disadvantage is a gross understatement. And the reason we have these rules is to prevent this exact situation. And the district attorney's office didn't cause the pandemic, but it is a policy to not give discovery before indictment. And that is a choice. And so, I think that just not knowing when he's going to be indicted is enough to, require a bond. But I understand that that's not going to be enough information for the court. So I'm perfectly happy to come back at 1:30 and find out what the answer is.
Ms. Ocam, tell me what you wanted to share as you got ready for today's bond hearing.
Your Honor, I don't believe that the state's position is that I don't believe that there's been a change in circumstances. He argued this before. The fact of the matter is still there was a shooting at a club with multiple people there, the defendants. Either way, defense attorney says he lives in Jersey, or he lives in Georgia. Either way, the fact of the matter is that he was in Jersey. He left Atlanta jurisdiction when it happened, went to Jersey and had to be picked up and found in Jersey. So if he has family in Jersey, he's not from here. If he's from here, if he lives in Georgia, and if he lives in Georgia, then he fled Georgia. If he lives in Jersey, that's where his family is, then he doesn't have ties here. Either way, the state's position is, either way you look at it, either he fled to Georgia or he's not from, either he fled to Jersey or he's not from Georgia. So he doesn't have significant ties to the community. That's the state's position. Your Honor, I will go and try and find out if I can get a specific date and time of when he's going to be indicted. I don't know if I can get, like Your Honor said, down to the science, but I will go as soon as this hearing is over and go talk to my deputy and see if we can find out, and I will let Mr. Munoz know exactly the date and time. I can CC the court so that the court knows that I found the information. This is the information I have.
So I want to make clear my expectation. It is not that someone would be able to give you date and time. This is more of a relativistic, where in the queue is Mr. Mewborn? And I think your colleagues in intake, and maybe it was restructured under the new DA, but I thought that Major Case had its own indictment crew. That's what Mr. Sprinkle used to do, is that he would help work up the cases for indictment. It may be that with the new intake team, they have to bless everything from murder all the way down to shoplifting. But regardless, whoever you need to talk to, Ms. Ocam, what I would like to learn is a good faith estimate as to when, meaning is it early May, is it late May, is it early June, is it late June? It does not need to be, I don't want you telling anyone there, the judge wants a date and time. That was your phrase, not mine. It does not need to be May 5th at 10 a.m. That is not a realistic demand. It is not my request. But it is fair to ask of the district attorney's office to give guidance that at least gets us into a half of a month. It's the first half of May, it's the second half of May. Because if the answer is it won't be until August, that is very different from it'll be in May. And that influences how I think about this. The other thing I'd ask is if you are able to get any basic information. I don't know where the case file is. I know it's not with you apparently. But if you're able to get police reports or anything like that, if you could get that to Mr. Moniz, and that doesn't need to be today, but if when you circle back with us, and I like Mr. Moniz's idea, is that you all can patch in at 1:30, and before we start with suppression motions with Anthony Carter, you can let us know what you learned. And it's okay if the answer is, I haven't learned anything yet, because this request is going to you at 9:40. I think it's enough time to pry an answer out of intake, but if you haven't gotten an answer, where you do need to be specific is, but I will have an answer by date and time, whatever that answer is going to be. So it's two things. One, intake's best good faith estimate of where in which month Mr. Mewborn case would be presented to a grand jury. First half or second half of which month? And then two, is there something substantive in the case file in whatever state it may be right now? I don't mean geographic state, but state of preparedness, that you could share with Mr. Moniz so that we're addressing sort of the due process concern beyond liberty rights of not letting stuff get too stale before it's handed over to the defense. And Mr. Moniz, given the tenor of your argument, I'm assuming that you have been retained for the long haul. You are not attorney for bond. Your expectation is you are attorney for resolution of the case.
I would expect that I'm going to be the attorney that tries the case, yes.
Okay, got it. So Ms. Okam, I didn't know what your schedule was today. Are you able to plug back in at 1:30 when we reconvene? It'll be for 2 minutes. It won't be long.
Yeah,
but
if it's for 2 minutes, yes, Your Honor, because I have to be somewhere else at 2.
Okay, yeah. So at 1:30, when we get back on, before we turn to Mr. Carter's motions, and so Mr. Mewborn, you will not be on. We will not be connected to the jail at 1:30. It's going to be Mr. Moniz who dials in, and Ms. Okam will dial in. But Mr. Mewborn is going to be at Rice Street. And I will consider the input that I got today from Mr. Moniz, and whatever we hear from Ms. Okam this afternoon as to how I will rule on the motion to reconsider bond in Mr. Mewborn's case. Mr. Mewborn, do you have anything you want to add?
Yeah, I'd just like to talk to my lawyer. Are we done with this?
Okay, so one way we could do that is there's only one more position on the calendar. If we handle that and you stick around, Mr. Mewborn, then when we're done with the last gentleman, you could come back in and we can just leave it, the two of you, on the situation. I can let everyone else go. Unless you're planning on getting out there, Mr. Moniz.
I can't get out there, but I also can't. I have another hearing that I need to attend.
Okay. Well, then, Mr. Mewborn, you're going to need to sort that out with Mr. Moniz, okay?
Shamik, I'll set up a call. It'll probably be tomorrow. They don't do same day video calls, but I'll set up a call.
All right.
Thank you, Your Honor.
All right. Thank you, everyone.
Thank you, Your Honor.
So 1:30, Moniz and Okam.
Yes, Your Honor.
Thank you.
All right.
Hi.
Ms. Hall, hey,
That concludes my business. Well, the other cases did. May I be excused?
you don't have Cortez Griffin. That's Ms. Sims?
Yes.
Okay. Maybe you can. Folks, you are here for what case? Okay. Can you say that again? Was it you there with you, Ms.
Yes.
Patel?
Yes.
Okay, great. All right. Yes, Ms. Hall. I will see you at 1:30.
Okay.
We won't see Ms. Patel. We'll see Mr. Melnick
Right.
now for
That's
Anthony
right.
Carter.
I'm going to try to watch.
I think it's all your motions.
Right.
They are. All right. See y'all later.
Bye. Mr. Griffin, how you doing?
Good, Judge.
Good morning. Mr. Griffin, you are on for plea and arraignment. I believe Ms. Patel is going to be your attorney. She is here in court. And Ms. Sims is the prosecutor handling the case. She is on this call. And all I've got on the calendar is that we're talking about plea and arraignment. Is it more than that, Ms. Patel?
Your Honor, I did file a bond motion a couple weeks ago, so I would like to address his bond.
Okay. Ms. Sims, are you in a position to talk about bond for Mr. Griffin?
Yes, I am, Your Honor.
Then we've got all the people we need. But let's start with arraignment first. Ms. Patel, are you waiving arraignment on behalf of Mr. Griffin?
Yes, Your Honor.
If you fill out a waiver form, I'll get it filed. If you leave it with me, and then we can talk about bond. So, Mr. Griffin, the waiver of arraignment is just Ms. Patel's way of acknowledging, yes, you're charged with these things. It allows me then to enter a scheduling order so that we can make sure your case is moving along. The scheduling order will give the state a deadline to produce discovery, the evidence in this case, other than testimony, to your lawyer, Ms. Patel. She'll look at the evidence. She'll look at it with you. Ms. Patel will decide if she's going to file any motions, because there'll be a deadline for that as well. And then if your case hasn't resolved, we'll get you a trial.
Yes, sir.
But for today, the bulk of what we're going to do is talk about bond. So Ms. Patel, you can finish filling that out when we're done. Why don't you get us started on the bond front, please?
Thank you, Judge. Mr. Griffin is 21 years old. He did graduate high school. Prior to his arrest, he was working with CDI.
What is that?
It is, I believe, a warehouse work. And then prior to the pandemic, he was doing concessions at the airport with Goldberg's. Currently, he's being supported by his father, Mr. Hudson, as well as his sister. Your Honor, the allegations in this case concern Mr. Griffin and his girlfriend. They have a child together. This situation between these two is fairly complicated. They're not cross defendants, but the complaining witness in this case, Ms. Gransberry, currently has a CP case in which Mr. Griffin is the victim in.
So it makes it difficult for you to talk to people and the state to talk to people.
Correct.
Okay. We've had this before.
With that being said, Ms. Gransberry was on this call. She seems to have dropped off.
We did have a Kana, and then there was one other person.
There was Jasmine G, and that was her.
Okay.
She does not fear Mr. Griffin should he be released on bond. Apparently, an affidavit was filled out, not at our office, perhaps a prosecutor's office, about waiving prosecution. I don't have that in my file. But, Your Honor, Mr. Griffin is 21 without any felony convictions. He's been in for about 6 months. The reason...
Because it wasn't indicted, or...
No, he had... So the case in which Ms. Gransberry has a felony charge, he got charged with a misdemeanor battery family violence.
In that same... Okay.
Right. And so I believe the initial first appearance judge did not like the fact that he had a prior with her and then now has this other case. I've had a lot of talks with my client as well as his family in terms of what to do. I do think this case is resolvable. I've talked to my client about it. Ms. Sims has been generous enough to send me all the discovery that she has. The indictment alleges a strangulation. I listened to the 911 call and I reviewed the body camera footage. And no strangulation is mentioned in there. So I have sent a subpoena to South Fulton to determine if there's any additional body cam, because what they provided Ms. Sims was only 4 minutes of footage, to see where that allegation is coming from.
It's 2 counts. We don't need to get into all the facts today, but I was just curious in looking at the indictment. Count 1 alleges strangulation, aggravated assault on the 30th of September of last year. And then count 5 is the same victim, same day, but it's clear it's a different set of acts than count 1. So it must have been a complicated day for the 2 of them.
To me, when I read the police report, it seemed like within this same altercation, Ms. Sims might have a different interpretation regarding that. Ultimately, Your Honor, what we're asking for is signature bond through pretrial services.
So there are no more signature bonds. There is, you may not have been on the last call, and we need to get the statute to your supervisors. There is unsecured judicial release.
Okay.
It's a terrible sounding thing, but it is by way of legislation that was effective initially January 1 of this year, but it has been further narrowed by a bill that became an act. There are very few offenses for which signature bonds, now UJR, can be entered. Now, you can enter a $1 bond, but the framework of recognizance, pretrial supervision, it's like theft by shoplifting. I mean, that's about it. And certainly it's not aggravated assault.
Is the 10% option still available?
It is, and so that may be how you want to think about it.
Right.
Because in fact, it now includes the ban against UJR, includes family violence battery. So they've drawn some pretty clear, and they added entering auto this session.
Gotcha.
So hence my observation that other than basically like theft by shoplifting or jaywalking, and it's not quite that narrow,
right.
There needs to be an actual secured bond.
I see.
As I said, it could be $1. I don't think a judge is going to want to sign something that says $1, but it complicates things. So just know that if I say I can't do a signature bond, it's not I might decide in the case I wouldn't do it anyway.
Right.
The legislature has decided for judges that UJR is now for pretty
Very
limited circumstances, which would not include this case.
right. Well, in this case, Your Honor, I would ask for a $10,000 pretrial bond through the 10% program.
Mm-hmm.
I did speak to his family. I think that they could afford that bond. I also believe that while I do think that I could resolve this case, I think that once Ms. Gransberry's case is indicted, it is very important that they both have parenting classes attached to their resolutions, and that there is a plan put in place for both of them that helps facilitate their childcare. They are in love, but very confused. And I think that everyone is in final agreement that even though they're in love, they need to stay separate and just work on co-parenting with this child. Should my client be released, he's not going to be residing with Ms. Gransberry. That's already finalized. That's not happening. He will be residing with Mr. Hudson. His father is actually getting knee surgery soon and will be wheelchair bound. So he absolutely needs Cortez's help, and Cortez won't have a choice. I think his family is up to here with the situation and does not, they're not going to tolerate it. They do have a pretty good arrangement right now with childcare. Jasmine drops the child off, and the family will watch their child. And so I think that could still continue where she's dropping it off and a family member is taking the child. But right now I've talked to my client at length about the fact that it doesn't matter if they both want to reconcile down the road. For now, they just really need to just work on co-parenting, and maybe down the road in resolving this case, there could be some therapy that's attached for both of them, but it's problematic right now.
So how no contact seems to make sense, but how would Mr. Griffin and Ms. Gransberry make arrangements for when, I think the child's name is Chase?
Yes, sir.
Okay, so how would Ms. Gransberry let Mr. Griffin know I'm bringing Chase by? She can't just show up unannounced and say, here's the young man.
She has all of their phone numbers.
Okay.
And they have been watching Chase while Mr. Griffin's been in, while
So-
she goes to work.
So Mr. Hudson and Mr. Griffin's sister would be willing to serve as points of contact. They're not signing up for childcare, but
Correct.
those would be the people who could be the intermediaries to call Ms. Gransberry to say, it's time to pick up Chase, or for Ms. Gransberry to call saying, I need to drop Chase off, or how are we going to arrange it?
Yes.
Okay.
And I think that they both struggled with this like no contact provision, because in the other case Miss Gransberry had, she was not supposed to have contact with Mr. Griffin. I'm not saying that she's at fault either, because they're both just very young, very confused individuals.
And I suspect they will have contact despite what I tell them. That there will be texts and this and
when I
that.
watched the body camera, she was lectured by the officers who were familiar with both of them. And my client he will say himself that this has been an eye-opening experience, and that he realizes that
6 months is a long time to be in jail for someone his age.
right. And, Mr. Hudson is incredibly frustrated because he said, my son's avoided being incarcerated, and it's not for drugs, it's not for theft, it's
Right.
for this DV incident.
Right.
And
He's not running and gunning.
today.
Yeah.
Right.
Is the expectation, and your client can answer this, or Mr. Hudson can, if you're not comfortable, would the expectation be that Mr. Griffin would be full-time caring for his father, or he could work and care for his father? Because I want to have as much structure in there as possible, so that he's not sitting around home with nothing to do, and then he hops on the phone and something unfortunate happens. But I don't want to require work if work is going to be making sure that dad and the knee are doing okay.
I think that we do want him working. At least when I spoke to his father yesterday, he said that that's where Cartez excels. He's really good at working. He's a hard worker. He wants to work. And I think that that structure is necessary for his day-to-day.
Okay. And Mr. Hudson, you agree with that having your son working is consistent with also taking care of you, or should he not be looking for a job while he's helping you? Okay. Okay. Do you hear that, Mr. Griffin? You're going to be working as well as taking care of your dad.
Yes, sir.
Okay. All right. Let me hear from Ms. Sims a little bit, and then I'll circle back to you, Ms. Patel. Ms. Sims, sounds like this is a complicated situation, as your cases often are.
Yes, Your Honor.
This one may be more so, because depending on where Ms. Gransberry's case gets assigned, you may be a prosecutor with defendant and victim on opposite sides of two cases. Either way, your office is going to have that. Tell me what you think ought to happen with bond in Mr. Griffin's case.
Your Honor, I guess we're going to defer to the court on this one. Definitely somewhat conflicted. We do understand how long he has been in, and it is a long time. But other than the January 2020 incident that defense counsel mentioned, there was a prior incident to that in September 12th of 2020, where, again, same parties. That time, only this defendant was arrested. And so he's out on bond on two cases. So now he has three cases involving the same victim. And we understand there is an interplay where neither is willing to stay away from the other. To be candid, our office did have contact with Ms. Gransberry, and she is not opposed to bond, which is to be expected, given that he has no prior criminal history, the amount of time he spent in jail, that all leans towards him getting a bond. But the primary concern is making sure somehow that they stay away from each other, because we do believe that he poses a threat of danger to Ms. Gransberry, excuse me, Your Honor. And we just really want to try and make sure that they stay away from each other and stay safe. And as Ms. Patel mentioned, they do have a child, and the child has been present during at least two of these incidents. And
right. That's the real victim.
Cruelty to children in the third-degree charge. So.
Yep. No, I think Chase is the real victim here. I don't mean to minimize what Ms. Gransberry's been through, or Mr. Griffin, insofar as he has been listed as the victim in an assault in the other direction. But if Chase is watching this and hearing this, that is bad parenting rule number one, is doing something like that. I mean, short of actually striking Chase, Chase seeing his parents strike each other, that's a terrible, terrible thing. Ms. Crawford, good morning.
Good morning, Judge McBurney.
How are you doing today?
I'm doing fine. How are you?
I'm okay. Do you agree that Mr. Griffin has no adult felony criminal history?
That's correct. He does not have a history with us.
All right. Thank you so much.
You're welcome.
So, Ms. Patel, I am inclined to set a bond along the lines of what you've described. I'll need you to get to Ms. Nelson, Mr. Hudson's full name, Mr. Griffin's sister's name, because I'll be including them in the bond as the only 2 points of contact for Ms. Gransberry to use to arrange transfers of custody. And same for Mr. Griffin, is that he and she work through Mr. Hudson, or what's your last name, ma'am? Griffin? Okay, or through Ms. Griffin to arrange the transfer of custody of Chase. We'll need Mr. Hudson's address. And I think that's it for the info I'll need from you to get to Ms. Nelson. Mr. Griffin, have you been able to hear everything we've been talking about?
Yes, sir. I heard everything.
So I know you're a young guy, but you got a lot on your shoulders. Number one, you got a dad who's going to need your help as he gets that new knee put in. Number two, you got Chase, who needs you to step up here and not be as tumultuous as maybe you've been with Ms. Gransberry. For now, the two of you, Ms. Gransberry and you cannot connect in any way. Obviously, can't be in the same place, but you need to not be texting or putting something on social media that you know she'll see. Whether it's something nice, I miss you, honey, or something bad, I can't believe you're bringing this on me. If the district attorney's office gets any evidence that you are trying to contact Ms. Gransberry and they bring that to me, you'll get a hearing, but I will likely pull your bond and you will be back at that place you don't want to be until your case is resolved. We just won't talk about bond anymore. It's that serious. It's not a trap. If Ms. Gransberry is reaching out to you, you just need to let Ms. Patel know. If she texts you, you save that text and you get it to Ms. Patel, because then I may need to have a conversation with Ms. Gransberry saying, now you aren't supposed to do that either. But if you respond to that text, Ms. Gransberry could bring that in and there's you communicating with her. So you need to go dark with Ms. Gransberry. And I don't mean to say that's easy, but it's just what you got to do if you are serious about staying out, taking care of your family. That includes 2 generations for you. That's Chase, that's your dad, keeping a job. It's going to be hard to be viewed as a valuable employee if you disappear for 6 months at a time because you're getting locked up. So I'm not lecturing you. I'm just trying to let you know sort of the stakes in this. It's just there's nothing Ms. Gransberry has to offer that is worth spending time with her right now. Maybe in the future, like your lawyer was saying, if things settle down and Chase is a little older and you guys both get some classes, then maybe reconnecting makes sense. But between now and that time, you just got to be real smart and real safe on that. Do you have any questions about what no contact means?
Oh, no, sir.
Okay. Do you have any sense of whether you could go back to the job you had, or are you going to have to start from scratch?
Well, I was thinking about a new job.
Like what?
Because I was receiving unemployment for that job, and I'm thinking about another warehouse job.
Okay. Well, there are lots of those, so I hope you find something. Ms. Sims, do you have anything else in terms of conditions you'd like to see on the bond? Obviously, number one for you and for me is no contact with Ms. Gransberry, but we'll have Mr. Griffin living with his dad. The points of contact for exchanging custody of child Chase will be dad and sister. And then there'll be a requirement that Mr. Griffin maintain employment or seek and maintain employment. I hope he finds something quickly. Anything else?
No, Your Honor, I believe that covers everything that the state was concerned about.
Okay. All right. Well, Ms. Patel, when you get that info to Ms. Nelson, she can get a draft bond to me. I will set the bond. I'll break it out across those counts, but it will total $10,000 through the sheriff's 10% program. And family, in case Ms. Patel hasn't explained it, a benefit of the sheriff's 10% program is that you get most of your money back. It's not like with a bonding company where you shell it out and the bonding company keeps it. The sheriff's office will keep that money. There's a little processing fee, but when Mr. Griffin's case is done, whatever done may mean, you're able to get most of what you put in to secure his release back. So it's more of a 0% investment in getting your son out than just spending with a bonding company. All right, Ms. Patel, if there's nothing else, I think we're done.
Yes, Your Honor. And just so the court is aware, the notices still say 1D. At least today's notices, the family has their paper notice and it said 1D.
You know, that's interesting. This calendar says 1D. The add-on says 8D. This afternoon's is 8D. So may have been a typo on our end. But I'll talk about it with the team. This particular calendar does say 1D, and I bet mea culpa, that's a mistake we made. So I'm sorry if you got to see 1D, but you made it to the right place. All right. I think that's it. Thank you, courtroom 3, for getting everyone to us.
All right, thank you, Your Honor.
Bye, Ms. Sims.
Bye.
Your Honor, Mr. Hudson had. Oh, I'll